Okay. Hi sir! This is our video assignment and I'm Avery Sim.
I'm Lian.
I'm Young Jing. I'm Rose Soo Chin.
And I'm Cassandra.
And yeah, I hope you enjoy our video. Bye! Before we address the main issue, let's establish what we already know. What is the existing structure of the government in the United Kingdom? There are three branches to the current government: the legislative branch, the executive branch, and the judicial branch. The first branch is the legislative branch. The legislative branch is well known as the Westminster Parliament, and the Parliament consists of three limbs. The first is the Crown, well known as Queen Elizabeth. The second is the House of Lords, which is a fully appointed chamber. The third is the House of Commons, which is a fully elected chamber. The House of Commons is known to be the most powerful component of the Parliament. This is because the members are elected every 5 years through a general election. The legislative branch has law-making powers. They have the power to initiate, renew, consolidate, and repeal laws. And a bill passed by the Parliament is known as an Act of Parliament. The next branch is the executive branch. The executive branch is known as the British government. The British government is led by Mr. David Cameron, which is the Prime Minister. The Prime Minister then goes on to elect more ministers into the government. The Prime Minister generally commands the confidence of the monarch. The executive branch formulates policies and is also responsible for its execution of those policies. The monarch has executive authority. However, this authority is exercised by the Prime Minister or on advice of the Prime Minister and the Cabinet. The last branch is the judiciary. The judicial branch is known as the Superior Judiciary of England. The Superior Judiciary of England has three courts. The first one is the Supreme Court, the second one is the Court of Appeal, and the third one is the High Court. This is the branch which adjudicates on conflicts between the states and institutions, state and individuals, and also between individuals. The judiciary interprets law enacted by the Parliament and also aims to uphold justice. With that said, those are the three branches of the government. Now the question is there a new and fourth branch of the government known as the integrity branch?
Well, the perception of this fourth branch, the integrity branch, is indeed a recognition that across the three previously mentioned branches, there exists a scope of the integrity function. Integrity is to do with earning and sustaining the public trust by serving the public interest, whereby powers are to be used responsibly, acting in an honest and transparent manner, while also acknowledging and preventing any conduct that would be improper. To phrase it differently, it means that the government's responsibilities and their actions have to align so that they can harmonize with each other. Many of the existing institutions of the three recognized branches of the government, including the Parliament, the Head of State, various executive agencies, and the Superior Courts, collectively constitute the integrity branch of the government. The role of the integrity branch is to ensure that the concept is realized, so that the performance of government functions is not corrupt. Not merely in the narrow sense that officials do not take bribes, but in the wider sense of observing proper practice. Integrity is broader than the absence of corruption. It looks at a wider concept that encompasses pathologies that are not solely on corruption, and instead further incorporate different forms of misconduct and improper action. But this does not mean that by acting improperly, it would not be considered as acting corruptly. In fact, any actions can accordingly be identified as actions which lack integrity. Besides that, this fourth branch safeguards that the government institution exercises powers granted to it, and in a method that is appropriate and with the only intention of the powers conferred to it. These purposes go beyond legality to include broader rights-based values. First, the maintenance of fidelity to the public purposes for the pursuit of which the institution is created, and second, the application of the public values, including procedural values, which the institution is expected to obey.
Interesting.
The purposes, as mentioned by Chief Justice Spiegelman, are not seen to correspond with administrative justice objectives, which are to juggle efficiency and effectiveness with individual justice. This is a difference that should be kept in mind when transposing and evaluating a method that will assess integrity and administrative justice.
And due to the fact that the integrity branch aims to maintain the decision-making process within the legal boundaries of the public sector, these formulate a noticeable relation with the administrative law. Therefore, in a way, the integrity branch echoes the words that are commonly used in the discourses of administrative law.
However, before we can even consider such a correlation, isn't there a warning that should be embraced?
Yes, this is because there's no definite or precise link between administrative law or the integrity branch. In fact, both are versatile and sophisticated. The scope of integrity is aimed at ensuring that institutions and personnel engage with their functions with fairness and morality in accordance with the law, so that the specified intended purpose can be achieved.
Wait, but why do we practice this integrity method in the government?
Let's see. One of the focuses is that there must be integrity with the expanding functions of the government, inclusive of roles that are associated with the powers that are covert and coercive, as well as the deprivation of liberty. These kinds of functions will engage concern in the assurance of integrity as to the exercise of these powers where necessary. Moreover, we have come to expect more from the government and possibly greater dependence on the government, and therefore it means that integrity agencies are more dependent on as well. It has therefore been established that if public officials act in a corrupt manner, for instance, accepting bribes, it can be deduced as having acted without integrity.
It is the job of the agencies who are entrusted with their detection, investigation, and reportage to ensure that governmental institutions are acting with integrity.
The problem now, as recognized by Professor Ackerman, is that the wider the jurisdiction of the integrity branch, the higher chance it will interrupt operations of the politically accountable authorities and institutions. Thus, the courts are no longer the only body that checks and curbs the powers of the government or other institutions, nor are they the practical influence. And so, we must consider whether Ombudsman can be the fourth branch of government.
Hello and welcome to the Forum on Ombudsman. Our three guests today are Dr. Chan, PhD in Law, Ms. Yong, Oxford University student, and Ms. Low, Senior Partner of ZICO. Let's get started now. So, what is Ombudsman?
Well, the Ombudsman is a public advocate that is usually appointed by the government or parliament to investigate complaints or maladministrations.
Interesting. So is the Ombudsman affiliated with the government then?
You can say so, yes they are, but the Ombudsman are usually given a significant amount of power of independence in investigating complaints.
So what role does the Ombudsman play?
Well, the Ombudsman play many roles to aid the public, but generally the principal role is to investigate and address complaints of dishonest or inefficient administration that violates the public rights.
Okay, noted. What method does Ombudsman use to address problems then?
The Ombudsman usually solves problems by way of a recommendation.
He can also solve issues through mediation if that's suitable.
Oh, okay. How many types of Ombudsman are there then?
In general, there are two types of Ombudsman existing in the United Kingdom, which are the Ombudsman on a national level or at a lower level. Essentially, they carry out similar roles, but they investigate different types of issues.
The role of the Ombudsman on a national level is similar to the role of an Inspector General that is appointed by the legislative, and the Ombudsman on the lower level is usually appointed by the state.
Alright. Can you elaborate on what the Ombudsman actually does then?
Well, in general, as I said previously, the role of an ombudsman is to investigate complaints of maladministration of the public power. As the ombudsman ensures the proper administration of executive power, he can be seen as a kind of check and balance of the executive.
The investigations of the Ombudsman are submitted to the public body in question, so in that sense they serve as a kind of advisory guide. I think that encourages proper administration of power, and it's also important to remember that the Ombudsman can investigate reports of maladministration and not only unlawful administration, so in that sense he has a broader scope than the tool of judicial review.
Okay, so does Ombudsman only have advisory powers?
Yes, that is correct. He only has the power to advise and doesn't have the power to enact or directly effect any changes in legislation. The bodies being investigated are under no obligation whatsoever to apply such suggestions as the Ombudsman suggests. As such, the role of the Ombudsman has been criticised for not having any remedial powers per se.
I see. If the Ombudsman merely has advisory powers, how can he guarantee that the power be administered in the manner that is expected to be?
Well, it's important to remember that should the body refuse to accept or acknowledge the findings of the Ombudsman, he can submit his investigations to the Parliament for further action. Should Parliament not act on his investigations, one can assume that his findings were either inconsequential or wrong.
Ms. Yong, your thoughts?
Oh, but if the matter of public interest, political pressure can incite the body in question, or Parliament for that matter, to take into account the Ombudsman's findings.
Ah, yes, like in the case of the debt of honour.
Ah, yeah, okay.
So would any one of you care to explain the case of the debt of honour then?
Yeah, actually it was a case regarding a compensation scheme for British interns who were interned by the Japanese in World War II. And several of the beneficiaries under the scheme were actually denied compensation because their parents or their grandparents had not been born in Britain. The Parliamentary Ombudsman made an investigation into the matter and submitted his findings to Parliament, but his findings were disregarded. And as such, as it was a matter of significant public contention, and under public pressure, government eventually allowed compensation against the beneficiaries in question.
Okay. Are there any other opinions from the rest?
Yes, there is. So in a way, the Ombudsman provides a sort of mechanism for the electorate to express their grievances and apply public pressure.
But let us not forget that this scenario will only apply if the matter at hand was of public concern. It is nevertheless legally acceptable for a Member of Parliament to dismiss the Ombudsman's findings, as held in the case of Bradley and the Work Pension Secretary.
Hi, would you like to look at a new pension scheme?
So, what do you want to have for lunch?
Excuse me, are you pension workers?
Yeah, we are.
Would you like to sign up for the government's new pension scheme?
What is it about? Here are some leaflets. You can read about it. We'll ensure the best for your family.
So, what do we do?
You knock.
You knock.
You knock.
Okay,
1, 2,
3.
Come in.
Morning, miss.
It's madam to you.
Morning, sorry, ma'am. These are the sign-ups we have for today.
Okay.
Put here. Alright.
the balance of the leaflets.
Okay, you may leave. Thank you. Wow, so many applicants today. These slips don't actually mention the risk of losing their money. No matter, we have the applications. That's all that matters.
What happened to all our money?
Wait, it doesn't say that there's a possibility of us losing money.
Why, government? Why? No! Wait a minute. These leaflets don't even state any relevant warnings. No disclosure of risk, maladministration. Can you read these leaflets?
Yes.
Are you aware that there's no warning that pension workers may lose their money?
So?
Perhaps you should effect some changes. Your administration is faulty.
I don't think so. Get out.
The court finds in favor of the claimant.
Guys, guess what? The claims are seated! Justice is real! Let's go again!
It was held by the Court of Appeal that technically a minister or public authority is allowed to dismiss an ombudsman's findings. This is because a public authority is not bound to accept the ombudsman's findings, but in order to dismiss the findings, there must be proper or reasonable grounds submitted. On the facts of this case, there were no proper or reasonable grounds submitted for dismissing the ombudsman's investigations, and as such, the appeal was quashed.
So, what, if any, are the shortcomings of an ombudsman?
Well, firstly, an ombudsman can only make recommendations to the agency concerned as they do not have determinative powers per se. And this is laid out in Section 10.2 of the Parliamentary Commissioners Act 1967. Furthermore, an ombudsman is not obliged to investigate all the complaints he receives.
Yes, I agree with that. And that means that he may be able to arbitrarily deny justice as he sees fit.
But that's not entirely true, because setting an obligation to investigate every complaint he receives would mean the ombudsman would be flooded with a lot of petty cases. Giving him a discretion serves as a sort of floodgate mechanism in that sense.
Ms. Young?
However, I have to admit that the Ombudsman does have the investigatory powers of a High Court judge. As provided by the Parliamentary Commissioner Act, under Section 8 of the Act, the Ombudsman can summon witnesses and require a public body to submit relevant information to the investigation.
Perhaps so, but another disadvantage is that the Ombudsman may not allow personal involvement of complaints in the investigation of their case. Most of the time, they don't have any right to a hearing or any control over how the investigation or adjudication on their case is conducted.
Well, now that I think about it, there is an MP filter under Section 5(1) of the Parliamentary Commissioner Act. And the Act states that in order for an ombudsman to investigate a complaint, he must be referred to by a Member of Parliament, and the Member of Parliament must receive a complaint from the public in order to refer a complaint to the ombudsman. So in that sense, it can be seen as a sort of limit on the effectiveness of the ombudsman.
Okay. Given the respective strengths and weaknesses of the ombudsman, do you think that we can class the ombudsman as a new and fourth integrity branch of the government, one that ensures the proper exercise of power of the other three branches?
Well, undoubtedly, the ombudsman serves as a check and balance on the executive, as I discussed previously.
That may be true, but the ombudsman does not check or balance the judiciary branch in any way. In fact, the ombudsman is checked and balanced by the judiciary as he is able to be judiciary reviewed.
Okay.
Yes, in a sense, the Ombudsman is capable of checking and balancing parliamentary power by submitting his recommendations and effectively pressuring the legislative into acting upon his findings.
Well, I admit that the Ombudsman may check and balance the legislative and the executive branches of government, but he has no power over the judiciary in any way. As such, I believe that the office of the Ombudsman cannot be considered as the fourth integrity branch of government, as it does not check all of the three existing branches of government.
Yeah, I think you're right. I agree. Because to be considered as an integrity branch, the ombudsman must check all branches of government.
Yeah. Yes, the executive, the legislative, and the judiciary should be included, not simply just the two of them.
Okay. Alright, that will be all regarding the discussion on ombudsman then. Thank you so much for all of your time.
Sure, thank you.
Establish what we already know. 1. You don't mean I can't use the issue. I'll go first. Is the crown. Queen Elizabeth now sits as in. Hi. Take 3,100. This authority is exercised by the. Sorry.
It's okay, continue.
Okay, this
Your thing has to be lower because I can't. There's such a huge. Officers is mentioned by Chief Justice. Covert and you laughed.
Operate in practice is realized, so that the performance of the government function.
However, before there is a voting, Charlie However, before we can consider such a correlation, there should be a consideration considered, right?
There must be a warning considered.
I know. Isn't there a warning that should be embraced?
Yes, that's right. Because there's no definite...
Hello and welcome to the forum of...
Wait, start again, start again.
Are we supposed to be smiling?
I don't know what we're supposed to do.
I think I'm just good.
No, like as you talk, what are we
In
supposed to do?
general, there are 2 types of ombudsmen existing in the UK. In the United Kingdom.
Submitted to the public body in question.
Ombudsman, does ombudsman only have advisory powers?
Here?
Shin, move your body left a bit because you're blocking the camera.
Here?
Yeah.
Here? Here? Okay.
Freaking Chan Lian, I can see the post laju. Stop! Stop! No! You at least you show this side lah. Don't show the post laju side. Okay, let's talk, guys. Talk.
Have you started?
Yeah.
Okay. Wait, it doesn't even say that there's a possibility of not us.
Have you seen these leaves?
Perhaps you should
I don't think so. Get out.
for the electorate to express their grievances and apply public pressure. Practically pressuring the legitimate. So in a way, the ombudsman